All right, good evening, everybody. It is 6:33, Monday, January 10th. This meeting of the South Orange Maplewood Board of Education is being live streamed as well as recorded for storage and viewing on our district website. The public can participate during hearings of individuals and delegates by signing up at a sheet at the front door, signing up for live audio or written public speaks through the BOE questions form on our website. Adequate written notice of this meeting of the South Orange Maplewood Board of Education has been sent to both townships and village clerks, the Star Ledger, the News Record, tapintoselma.net, and the Village Green. Please rise for the Pledge of Allegiance. Mr. Burnside, please note for the record all board members said they would be in attendance this evening, and with that, will you please call the roll?
Board Member Susan Bergen.
Here.
Board President Thayer Joshua.
Here.
Board Member Alyssa Malesena.
Here.
Student Representative Noah Morose.
Here.
Board Member Aaron Siders.
Here.
Board Member Carly Telsford.
Here.
Board Member Arun Vadlamani.
Here.
Board Member Caitlin Whitlatter. I see her.
Yeah, she's there, she's speaking, but oh, here she is.
Okay. Board Member Courtney Wingfield.
Here.
Board Member Johanna Wright. Board Member Johanna Wright.
You're muted, Board Member Wright.
All present.
All right, we'll just note it when maybe there's a tech issue, but we see the picture, so thanks. All righty, I'd like to make a motion to hold this meeting in a hybrid manner. May I have a second? Thank you, Board Member Bergen. All in favor? All right, that appears to be unanimous. Mr. Burnside? All right, we move on to the board statement. The school board meeting is a business meeting in public, not a meeting with the public. Oftentimes, it may appear to members of our audience that the Board of Education takes action with very little comment, and in many cases, a unanimous vote. Before a matter is placed on the agenda at a public meeting, the administration has thoroughly reviewed the matter with the superintendent. If the superintendent is satisfied the matter is ready to be presented to the board, it is referred to the appropriate board committee. Members of that committee work with the administration and superintendent to assure members fully understand the matter. After the committee discusses the matter, it is then shared with other board members for consideration, and only then is it placed on the agenda for board discussion at a public meeting. Excuse me. We are now at the time for public speaks, also known as hearings of individuals and delegates. This is an opportunity for you to share your concerns about an item on the agenda, but it's not a time for dialogue with the board. Board requests that you state your name and the town of residence for the record. We will set the time to 3 minutes for each speaker, and we ask that you respect that time limit. We must cut you off so it does not appear as if we are giving anyone an advantage to share their views over another individual. Speakers have the full protection of free speech during public speaks. However, this forum does not protect you from the subject of your free speech pursuing libel or slander charges. Finally, the board recommends that all members of our community pursue the chain of command. Mr. Burnside, I presume there's no in-person public speaks? And I'm now going to click on the audio or written comment. Okay, we have one written comment. Give me 1 second here. I'm going to set the timer to 3 minutes. Give me 1 second here. Clock the timer. And before we get started, I just want to make sure I can read this whole thing. Okay, our first public speaks is from Malia Herman of Maplewood. Hello, Dr. Taylor, members of the Board of Education. I'm Malia Herman, a Maplewood resident, mother of two, and president of SOMA CPAC, our district special ed parent advisory committee. Our CPAC board would like to welcome the new members to the BOE. We look forward to working with you. As you know, New Jersey law specifies that each district board of education shall ensure that a special education parent advisory group is in place in the district to provide input to the district on issues concerning students with disabilities, and that's according to NJAC 6A:14-1.2 parentheses H. Our district is fortunate to have an active parent-led CPAC. We meet monthly with the Assistant Superintendent of Special Services and quarterly with the Superintendent to provide feedback on what we are hearing from parents in the special education community. Additionally, two CPAC board members are a part of President's Council, which meets monthly with Dr. Taylor. We have CPAC liaisons at each school, and we plan to hold monthly meetings, hold monthly meetings with parents. However, despite CPAC being a legally mandated entity, there is no current official connection between the Board of Ed and CPAC. That was not always the case. Only a few years ago, there was a specific board member designated as a liaison to CPAC. This board member would typically attend our meetings as well as stay in contact with CPAC leadership. We are speaking to you tonight to consider adding that role back. There are 1,121 children in our district with IEPs, a number that would be higher if you included those with 504s. Out of our district-wide enrollment of 7,000, special education students comprise at least 16% more if you include children with 504s. With the number of policies that the Board of Ed considers each year and the number of challenges facing special education children, we feel it's time for the board to reinstate a liaison to CPAC. Board members are elected by the community to serve the students of our district. We'd like to help you serve them better. Thank you. Again, and that was Malia Herman of Maplewood. And that concludes our first public speaks. All right, we'll now move on to the board retreat.
Excuse me, Board President Joshua, can you
Yes,
just
Ms. Butler.
can you confirm for the record that there are no audio public speaks on there? I didn't hear you say that.
Correct, there are no audio public speaks on here. This is just
Thank
the
you.
one. It's just, yeah, so just for, it's a consolidated sheet now, so we just have to look at one instead of two. And now we are here for the presentation this evening. I don't know if Dr. Taylor or Ms. Butler, either one of you want to do an introduction for our guest this evening?
Just want to say good evening to all of our board members and members of the public. For those who may not know, harassment, intimidation, and bullying is a high priority for this district and our Board of Education and Administration. We often discuss the HIB cases that rise to the level of review by the administration and the Board of Education. We have a belief, again, in the growth mindset and to always be improving on our practices and our protocols. To that end, with new board members, we thought it would be a great idea to bring in a vendor to give us some expertise and professional development for the board in this important topic of HIB. Ms. Butler, anything that I miss? Well, I'm sorry, I just said, and we thought it would be a high priority for us to bring in an expert vendor to provide this professional development to our board. Anything to add?
No, that's it. It is such a big issue that faces this district and, of course, all school districts in New Jersey, but this board is committed to making sure that harassment, intimidation, and bullying are ideally eliminated. And with the monthly reporting that must be done to the board, it's important that all of the board members understand the legal criteria for what constitutes harassment, intimidation, and bullying, and then the parameters of what can be done as part of investigation and then as follow-up. So utilizing the vendor to provide this training, we hope that all of you take it all in, ask questions. I don't know how Sandra Jacques wants to handle questions. That we'll have to find out directly from her.
Good evening. Thank you for inviting me today. You're welcome to ask questions as we go through the presentation. If you want to wait till the end, that's fine too, but I'm yours for the evening. So whichever way you're more comfortable asking, be my guest. I did prepare a PowerPoint, which I'll put up on the screen in a moment after I give you a little bit about me. Given that I was told there were a number of new board members as well, I took the liberty of, just for convenience sake, so that you can perhaps use my PowerPoint as a reference in future, I gave you some basics about board interactions with the personnel, Oprah, OPMA, and things along those lines. So they're there with links and stuff to help you out, so you can click on them. And then I'll go through the HIB. I've read your policy, so I know what your district policy is. And I also put a little bit about free speech in there as well, because 9 times out of 10, one of the most common defenses is I have a First Amendment right to say whatever I want. And while people can say what they want, it doesn't mean they won't necessarily be disciplined for it. So I'll give you a very quick overview on looking at that as well, because you may see some of those issues coming along. Okay, my name is Sandra Jakes. I am an attorney. Please don't hold that word against me. In my civil litigator days, I was a defense attorney. I used to defend school districts, businesses, and such when they were sued for a variety of issues, discrimination, negligence, and things along those lines. This is now what I do for a living, in addition to teaching these courses to district personnel. I'm also an adjunct professor at Ramapo and NJCU. I teach the school law course in their respective master's programs for future school administrators. So I talk about this stuff a lot. This is actually all that I do all the time. You are welcome to ask me any questions that you like, but please do understand I am not your private counsel, nor am I the district's board attorney. So I cannot give you a specific, here, go do this now kind of thing. My function here is to give you an overview of what the law is and hopefully clarify it and make it a little easier to understand. I will say as well, if you hit me with a question I don't know the answer to, which is possible, I would ask you just send me an email with the question, and then I will go find the answer or find someone who can give me the answer to whatever your question may be about the application of the law. So with that, I will share my PowerPoint. Any objection to me sharing the PowerPoint? Are we all set to go? Okay, I got a thumbs up, so I will, and I practiced before we came on, so I know it worked then. You will have this PowerPoint available to you. There is a Dropbox link. Can you all see the PowerPoint? Someone say yes, please.
Yes, we can see it.
Thank you. I can only see 3.
Small though.
Yeah,
And
I'm going to make it bigger in a moment.
awesome.
I can only see 3 of you on my screen right now. So there, is that better? Okay.
Better.
Yes.
So the link is provided to my contact with you, where you will be able to access through the Dropbox. It's typically available for 30 days. We only do that because the law is constantly changing. So we want to make sure that you're getting the most current information all the time. If you miss getting it in the Dropbox, just let me know. I can send it to you. I wrote it, so I can send it to you. But feel free to download it, turnkey it, do whatever you want to do with it there. There's the disclaimer in writing that I mentioned as well. And there's the link to the materials, which you will also have access to as of tomorrow morning. So as I mentioned earlier, I've put these here for the convenience of the new board members. You can see the general topics that are there so that you don't have to go hunting for this stuff. I'm sure your board attorney will cover a lot of this with you, but I put this together just as a quick reference so that you can have it, and talking about interacting with district personnel as well, with a couple of decisions. You'll find with my PowerPoints, I'm a big believer in, don't take my word for it, here's a case or a law where it really happened. So you can see this stuff put into effect. And as you can see, I try to give you very current cases. These are all pretty recent. So there's a link for all of the financial disclosure questions you may have. As you can see, it was last updated in February. So if they're going to do it again, it would probably be this February. But that's there. Oprah, people get a lot of questions about that. So you have all of the specifics about that in there. OPMA, that's there for you as well. Okay. Closed session topics, what you can and cannot talk about, things along those lines. So getting to the HIB overview and some recent HIB case examples. The overall process in HIB, just so that you know your place in how all of this works, is that something is reported, it gets reported to the school administrator. In the very beginning, when this law was first implemented in 2011, a lot of people made a mistake of reporting to the anti-bullying specialist. That is not how it works. It gets reported to the administrator first. And if it's deemed to be something the ABS needs to investigate, then it's turned over to the ABS. The reason I say that is the original process for analyzing a HIB claim was someone reports someone did something to someone else. And if they use the words harassment, intimidation, or bullying, I refer to those as the three magic words, hence HIB. Under the original law, it was automatic that that had to go to the ABS and go through this whole process that takes in the ballpark of a month all the way up to the Board of Ed. However, in 2018, amendments were passed. And if your district chose to do so, which yours did, it was possible to adopt an amendment to your board policy that would change the process a little bit. So under the new process, which is part of your board policy, anyone that wants to see this, if you go to the district website, look under Board of Education, look under policies, look under HIB, and it's in section G of your school district policy. This tells you in your policy what I'm about to tell you now, is that if someone reports there was an incident, it doesn't matter who it is, a parent, a teacher, another student, someone calls it in. Even if they use the words HIB, your harassment, intimidation, or bullying, your administrator has the ability to do what's called a threshold assessment. So they can do some initial fact gathering. And in the clear-cut cases where it's clearly not going to meet the legal definition of HIB, they have the ability to consult with the ABS, just as a double check, and then determine, no, this is code of conduct, it's not HIB. So we're going to treat it as code of conduct as opposed to HIB. Now, there's still a reporting requirement under the 2018 amendments that the parent must be notified or guardian must be notified of this decision. And that's the opportunity for the administrator to explain why it's a code of conduct and not a HIB. The parent will then have the opportunity to appeal that administrator's decision to the Board of Ed. And then you would hear that in a closed session hearing and determine whether you agree with the administrator or not, and it would proceed accordingly. In the event that it is determined that it possibly could be a HIB or seems like it, or it's just one of those, I really don't know one way or the other kind of things, those get turned over to the ABS, the anti-bullying specialist. The only ones that you can exercise this option is where it's a clear-cut, nope, doesn't meet the legal requirements. And I'm going to go through what the legal requirements are in a moment. So once the administrator officially turns it over to the ABS, they have 10 school days to complete their investigation. And they have to submit a report, and the report is required within 10 school days. So it's very important that this stuff turns over pretty quickly. They have to find a yes, it is a HIB, or no, it is not a HIB. And they have to identify the legal elements, which I will go through in a moment. They then send that to the superintendent. The superintendent, when they review the ABS's report, they can either agree or disagree with the report. If they agree with the report, that gets sent up to you, the board. If the superintendent disagrees with the report, the superintendent writes their own report, and then both go up to you as the board, and you guys are the tiebreakers. You decide which way you're going to come down. You have to determine two things when you see these claims come before you. The first is whatever was done, does it meet the legal requirements of a HIB? You'll have a yes or no answer to that. Then you have to ask, was the discipline appropriate for whatever the act was? And understand, it is possible that you may determine, well, no, this wasn't a HIB, but it's still a code of conduct violation. And so this discipline is still appropriate for that code of conduct violation. But when these things get appealed to the courts, those are the two things the courts look at. And they are two completely separate issues. Whatever discipline may be imposed on the person that commits the HIB is irrelevant to determining whether or not it is a HIB. So as an example, if you know a kid's going to get suspended, if it's deemed this is a HIB, that's irrelevant to whether you determine it is or it is not a HIB. If you know that a staff member will get brought up on conduct unbecoming charges because this has been brought against them, that's irrelevant to determining whether it is or is not a HIB. Okay? And understand they have to meet the elements for a HIB. Just because it may not be a HIB, it still can be a code of conduct violation for staff or student. The other thing is the HIB law, the Anti-Bullying Bill of Rights, only protects students. It is not a staff-to-staff thing. So if you have a staff member, a teacher that says, the teacher in the next room is harassing, intimidating, and bullying me, that is not a HIB claim under New Jersey law. That's something the HR department deals with. But that is not a HIB claim. You don't do this HIB analysis with it. It only,
Can you hear Sandra, Ms. Jocks? We
Yes.
can't hear you. Give us 1 second.
Can you hear me now? Hello? Can you hear me?
I can hear you in the WebEx.
I
I'm
can
just
hear you,
looking to hear
Sandra,
you
but
on-
hold on.
1 second.
Yeah, we can hear you from the WebEx, but I guess they're having
But we-
trouble meeting.
We lost your connection.
Yeah. Yeah, hold on.
Okay, you're back.
Okay. Good to go?
Give us 1
Good to go.
second.
Okay. You tell me when.
Sandra, can you hear us?
I can.
All right, great. We can hear you now. Thank you.
Okay. All right. So as I was saying, the HIB law does not protect staff. It is only something that protects students. And understand anyone can commit a HIB against a student, a fellow student, anyone in the district building, anyone can be accused. Any district employee or agent can be accused of having committed a HIB against a student. And the same analysis applies to both. The other thing to understand is that under due process, there is no presumption either way. So both sides have to have an equal hearing. And if you get to a case where it's, I really don't know. I really don't know. Nothing is tipping the scales one way or the other for me to decide. Then you find in favor of the accused. Okay, the legal standard is preponderance of the evidence. Something has to tip that scale to make you think that one side is more likely than not what happened. If you're at a dead, I don't know. There are 2 kids involved. We don't have a recording. We don't have a video. And they're saying completely opposite things, and they're both credible and believable. I don't know who to believe. You're going to find in favor of the accused, not the accuser. Okay? Because just because someone is accused of something does not mean it's true. So you have to be fair to both sides. And this applies to staff as well. Okay? I would also caution with staff, it should be remembered that they have Weingarten rights, that they may need to have a rep present if they're being interviewed for purposes of an accusation against them. If they're merely a witness, that's not necessarily a Weingarten issue. But if they're the one that's accused, there's probably going to be union involvement as well. Okay, so bear that in mind. So it comes up to you, the Board of Ed, you render a decision. Something must be put out in writing, whether it's directly from the board or from the district, depends on however you decide you want to do it, that states, here is our decision, and it goes to all of the interested parties. So you have to say yes or no, it is a HIB, and the discipline is because of the HIB finding, the code of conduct, or whatever it is. That is imperative because that triggers the statute of limitations for the appeal period. If you, the district, never send out you, the board, never send out your letter with your decision, the statute of limitations does not start running. So in order to get that 90-day statute of limitations to start running, there has to be a written decision that gets sent out. Again, that's a due process issue. So everyone's aware of what the decision was. Everyone's aware of where you are, and you decide from there. Okay? So Both sides have the right to appeal the decision, and then it would go from there. And then what would happen was, once it gets into the court system, the ALJ and the commissioner, and some of the extreme cases go all the way up into the Superior Court of New Jersey, would analyze, did you do it right or did you not? And that's what they look at. Okay, so that is the process. That's where you fit into the process. Any questions about that before I move on? Okay, you are not involved in the investigation portion. You know, if your neighbor says, hey, my kid's being bullied at school, then you notify whoever, you will notify the superintendent, because remember, all your communications go down through the superintendent, and they will notify the school, and you advise your neighbor, contact the principal, contact the administration there. You don't show up and do the investigation yourself.
Josh, we do have one question here in the room on that. Board Member Bergen.
Thank you. I had a question about the ABS report, investigation report,
Okay.
and what are the elements of a good report and best practices, like how thorough and formal should it be?
It's very formal. Most of them use a systematic approach, and what should be in it is what I'm about to tell you when I explain the law. So that the long story, the quick answer to your question is it should be very clear, kind of like an IEP. You'll look at it and you don't have to hunt to figure out what's going on. You can see what the problem is, how it's being handled, what's done, and why they decided that. Same thing here. It would be, is it a yes or no finding of a HIB? What was the distinguishing characteristic? What was the substantial disruption? And I'm going to go through what those things are. And do understand, for a HIB, you have to have both things in order for it to be a HIB, both a distinguishing characteristic and a substantial disruption. If you're missing one of those two, it may be a code of conduct violation, but it is not a HIB.
Okay, thank you. We have one more from Board Member Malesena.
Sure.
Yes, I have a question, and maybe this is later, but if the board has concerns about a report or the process that a report went through, like the process that it was investigated, a claim was investigated, how do we deal with something like that? What is the best way for us to deal with that if there have been, say, allegations made or something like that, that it wasn't investigated properly? How would we, as a board, deal with that?
Well, you would analyze what you have in front of you. You can request to talk to the ABS in your closed session hearing. You don't have to, but you can request. You know, but a lot of it is looking at the credibility of what was done. And it should be pretty easy to look at the report, and if there's no supporting evidence for why they found one way or the other, then that may affect your credibility as to whether you agree or disagree with the ABS's finding. If it's asking for clarification on something, by all means do it, but just make sure you do it expeditiously, because there are requirements under the law with the due process requirements. It has to be done very quickly. This is one of those ones, unlike discrimination claims where it's a reasonable amount of time for the investigation. With the ABS, they have 10 school days. And you may get a situation, particularly once we go into back with hybrid situations, or God forbid we go back to a virtual situation, where you may get a report that says we'll supplement. And you know, you look at what you have at that point, see if you agree with what's been done or not done to that point, and then when you get the supplemental information, you proceed that way. The other one that I will tell you hopefully it does not, but you may have a situation that, unfortunately, just so you understand the procedure, unfortunately involves the police, okay? If the police, unfortunately, are involved and they're investigating a situation, what will happen is they will come in and they will say, stop doing your investigation, which they have the legal right to do. They have a higher burden of proof. They have other issues. I mean, if you have a police issue, you could be going to jail, as opposed to here, maybe you're going to get suspended or detention or something along those lines. Okay. They are higher, and they have more investigatory issues and higher hurdles to jump through. So let's say, for example, they come in on day 5. And they will put something in writing. It's not simply a phone call or a comment to someone at a football game or a board meeting or something like that. There has to be a formal request in writing, barring an undercover operation. That's a whole separate issue that they would deal with, where they say, we need you to stop this investigation. Okay. What happens then is that all parties are notified as per police request. We have stopped the investigation. If you wish to object to this, you can appeal to the local prosecutor's office, and it doesn't cost anything. They can appeal to the local prosecutor's office to have a judge either agree that the police can tell you to stop investigating or overturn that and say, no, school, go ahead and investigate. Okay. Regardless of what happens in that vein, if the police come in and say, stop investigating, you stop investigating until you get a court order or otherwise, or the police telling the district to continue investigating. So even though you're not investigating, you still have an obligation for student safety. So it may be keeping the kids apart. It may be something along those lines. And the thing is, if it's going to be a HIB, it's also going to be a code of conduct violation. So you may be able to do things under the code of conduct, not necessarily under the HIB. But the thought process behind this is basically they don't want the school district personnel, good intentioned as they are, to mess up the police investigation or to get in the way of the police investigation. So let's say the police come in on day 5 and they tell you stop. So the ABS will document that, they'll note it, they'll send that report out, they'll say it to be supplemented. And let's say 6 months later, the police come back and they say, okay, you can pick up your investigation again. The district then, the ABS then has 5 more days to complete their investigation. Remember I said you get 10, they get 10. So if the police order them to stop on day 5, when they're allowed to start again, they have 5 more and you would get the rest. You would get whatever information they find after that. That's one of the extreme situations. Hopefully you don't have to deal with that, but that is how that works. Just so that you're meeting all due process requirements under the law. Okay.
Great, thank you. Dr. Taylor, then Board Member Wright, and then back to Board Member Bergen.
Hi, so just to be clear, and thank you for this review. Every month when we're giving our board their update on the HIBs that have been investigated, in your experience, if 1 or 2 or less than the majority of board members have a specific concern or question about a particular investigation, would you recommend through your best practices that you've seen that when being pulled for further investigation? Just following up on Board Member Malesena's question, because I think it's important that the board leave understanding what happens if not the full board, but maybe some board members have authentic concerns about a particular investigation. Are there any ramifications that could negatively impact the school district or the board by those being pulled for further look?
Well, the delay in the process of getting done, there could be potential litigation of you didn't meet the statutory requirement of completing the investigation in a timely manner. And you should be able to, I always say you should be able to justify on paper why you're doing what you're doing. So if you feel something is missing, it shouldn't be one of these nebulous conversations, well, you know, it just doesn't feel right. You should be able to put down I don't understand why X is. You didn't list the distinguishing characteristic. Did you identify a distinguishing characteristic or something along those lines? What's been happening in the litigation, when it goes up into litigation, is that if the court or the commissioner or the ALJ determines that the school did it wrong in whatever manner, what's been happening is they've been sending it back to the school to do the whole process all over again. Okay, so they haven't been throwing them out or anything like that. They either affirm them or they remand them back and say, fix your process and do it again and do it right this time. So you're sort of that last line of making sure everything to you to that point has been done right. So if your ABS has not identified a distinguishing characteristic or point blank said there is no distinguishing characteristic that can be identified, you're missing some element of that report. Or if they don't say the substantial disruption is, and then they articulate what it is, or they don't say there was not a substantial disruption, here's what action, that type of thing, they have not done what they're supposed to do. You need to understand, because litigation is very different from normal people, okay? In that you can't just assume, well, everybody knows that. No, everybody doesn't know that. In a legal setting, if it's not in writing, it didn't happen. So those reports, and most districts do have the set reports that they basically, it's a fill in the blank kind of thing with these things, where you'll identify the distinguishing characteristic, what the substantial disruption is, or the lack thereof of one or both of those elements. And if you're missing even one of those elements, it is not a HIB. It can still be a code of conduct, but it will not be a HIB. Okay?
Thank you. Board Member Wright.
I can't hear anything.
Board Member Wright, we can't hear you. Why don't you go back out and then go back in again?
All right, while we wait for that, let's go to Board Member Bergen.
Thank you. I just wanted to clarify something on this slide. Does the board get every HIB report or only the HIB reports for things that are being appealed or where the superintendent might disagree with the investigator?
No, you get every HIB report. That was a mistake a lot of districts made in the beginning. They only sent the ones up where the ABS found HIB. And that's not true, because you have the right, after you consult about it with each other, of overturning either way. If the ABS finds there was not a HIB, you can disagree and say, well, yeah, we do think it was a HIB. Or if they find that it was a HIB, you can disagree and say, no, we don't think this meets the requirements of a HIB.
Okay, thank you. Board Member Wright is in the process of fixing that. So I'm going to come back to Board Member Malesena.
So would you suggest, I guess following up on what Board Member Bergen said, would you suggest right now we get a summary, like sheet that's a summary that, goes into a little detail, but we don't see the entire, we use Hipster, so we don't see like the entire Hipster report with everything. Mm-hmm. Should we be seeing that? Is that the best way to handle that? Or is it, and should we be getting them like when they come in, or, like after the investigation's been done, instead of at the end of the month where we're getting like one big document that we're approving?
Let me say that you don't want to be reviewing unnecessarily copious amounts of documents just to look at the entire file. Of course, you want to do your due diligence. So what I would say is maybe the reports you're getting just aren't detailed enough, or the summaries you're getting are not detailed enough. You don't need to necessarily read every witness statement or every, there were 20 kids that witnessed the fight, and they talked to all 20 of the kids. You don't necessarily need to read all 20 of those statements, type of thing. But it perhaps might be, Hipster and those programs are only as good as the person entering the information. So it might be that they just need to put in a little more detailed information to substantiate whatever it is that they found or did not find.
Thank you.
Does that make sense? Is that good?
I think that makes sense. I think my only concern, I guess, going back to something, is that you said that if the once a month, we only get once a month. And it seems like if say I get something once a month and then there's a concern about something once a month, then if I say we need to relook at that, then we're over the time limit. So I guess I'm trying to figure out what the best way is to deal with that.
The specific time limit is the 10-day investigation window for the ABS.
Okay.
The rest is in a reasonable amount of time. And it's based on when your board hearings are.
Okay.
If you do what you need to do, but what I would say is if there's going to be a delay for some reason, make sure you can justify in writing why you have that delay. It can't just be you know what, we didn't get to it this time, we're not going to do it. That's not a justifiable reason. There has to be all the power was out in the city for that day, or it was a blizzard and power was down, or we couldn't get a hold of people. The witnesses were gone. Someone retired and moved to Florida, and we couldn't talk to that witness. You should be able to justify why there's a delay in whatever caused your delay.
Thank you for that. The one thing I just want to clarify for everybody, especially the new board members, is that when we get the report once a month, it's not just things that happened in that last month. It's things that got reported to us within that month. So there are instances where there is a time delay as they're doing the investigation from when the incident may have occurred to when it gets reported to us. So I just wanted to clarify that one piece of it. I see Board Member Whitletter has her hand up.
I'm sorry, I can't hear you. I think you're muted.
Yeah, if you're speaking.
Can you hear me?
Yes, we
I
can.
can.
Go ahead.
Sorry. Quick question. I see that the requirement is for faculty to report the same school day when a HIB violation potentially occurs. If they do not report the same day, is there an implication to that timeline, that 10-day investigation timeline for the ABS to conduct their investigation?
No. What it is once a member of the district knows about this, because all employees of the district are agents of the district, it's deemed the district knows. So that does not delay or toll the 10-day requirement. Okay. In doing these investigations, what I would say is that it's a potential disciplinary action against the staff member if they're not following this procedure. So it's a verbal report as soon as they know about it, or within the one school day. And then the law requires filling out whatever form your district requires within 2 school days of the incident happening. A number of districts, I apologize, I don't know if your district has done this or not, but a number of districts do require that it be 1 school day instead of 2. It is legal to do that if the district has decided to do that. And it's just a basic, here's what I was told, here's what's going on. But from moving in a reasonable time period, no, because once your employee knows, the district knows. So it's imperative that there's training for a lot of people, particularly the ones that don't understand this the most. And unfortunately, they're the ones that know about them the most, are the people that live in town, that work in town, that work for the district but live in town. Your custodians, your aides, your lunch ladies, they all have the same reporting requirements as any other staff member, because once they know, the district knows. So it's imperative that it's understand. You just got to tell the administrator, and then they take it from there. And following up on the other point too about sometimes there's a delay. There have been instances where something happens over the summer or the year before, but it doesn't get reported till you show up again in September. The district still has to investigate that. And once they're aware of it, that's when your 10 days kick in, 10 school days kick in for doing the investigation.
All right, thank you. Board Member Wright, I see you're back. Can you try again?
Can you hear me?
Yeah, but now it seems like you're on twice. It looks like you dialed in and you're on. So mute yourself in the video and try again.
Is it possible maybe if there's a chat, she can type in a question?
Okay. Hello? Oh, wow. I'm sorry.
How would you like me to proceed? Do you want me to wait a little bit longer, or do you want me to keep going? You tell me what to do. Keep going? Okay, I'll keep going. So I'll give you an example and understand this is why I have a day job, okay? Many people confuse this. And there's a big difference between the legal definition of HIB and the common everyday use of the word bullying, or even the psychological definition of the word bullying. So I'll give you an example. Let's say I'm a student in your school and I'm in a really bad mood one day. And so I'm walking down the hallway and I just feel like hitting someone. And the first person that walks in front of me, I don't know them, they don't know me, we have nothing to do with each other. They're just in the wrong place at the wrong time because I feel like hitting someone at that moment and I hit them. Under New Jersey law, that is not a HIB. It's a code of conduct violation because I can't go around randomly hitting people, but it is not a HIB. Okay? So it's important to understand that, and I'm going to explain how all this puts in. When I was going through the process, I explained there are 2 requirements you have to have. So going through it, here's the legal definition. This is in your policy. This is also in the law. HIB is any gesture, written, verbal, physical act, or electronic communication, which unfortunately that's where a lot of this stuff is now, whether it's once or a bunch of times, that is reasonably perceived as being motivated either by an actual or perceived characteristic. That's the first element. You have to have to take the legalese out of it, you have to have a reason why this kid was targeted. So going to my randomly punching the first person that walked in front of me in the hallway because when I was in a bad mood, there's no distinguishing characteristic. I would have hit anyone that happened to be in the wrong place at the wrong time. That's why that particular one would not be a HIB. So going back to your policy under section G that allows a threshold assessment, the administrator does the investigation. Both sides, both me and the kid that I hit say, no, we don't know each other. We have nothing to do with each other. And you get me to say, look, I was just in a bad mood. I felt like hitting someone. That was the first person I saw, so I hit him. That's a clear cut. It's not going to meet the legal requirements. So that would be the type of incident that you would, again, just do a double check with the ABS, but then say, we're going to treat it as code of conduct, not as HIB, because it's not going to meet the legal requirements of a HIB. Okay? So there has to be a characteristic, and I go into those in a moment. Then we have that takes place on school property at any school-sponsored function on a bus or off school grounds. Basically, it's 24 hours a day, 7 days a week, 365 days a year. And I'll get into how that applies in a moment. I see a hand up somewhere.
Miss Wright, I'm sorry. Can Miss Wright try again? I was just trying to help her with her computer. Can we try to see if her audio is working? Miss Wright, can you unmute yourself and try again? I guess not. Sorry.
It's okay.
I was trying to help her, but she's not great with
Okay,
technology.
wait, Board Member Malesena, 1 second. We have a question in the room, so we're going to handle that first, all right? Go ahead, Ms. Moore.
Hi, Sandra. Thank you for coming.
Sure.
So my question was, as you're talking about these, the slide before here, and it's talking about the difference between bullying and, of course, a code of conduct, because this is the thing that comes up quite often, and it ties into the conversation that was happening before. So I know it has to meet that definition of a distinguishing characteristic, and the conversation that we were having before, if it doesn't meet all those distinguishing characteristics, in particular, my question is whether or not, do we report, does the board have to get the report on the code of conduct as well, including the HIBs?
Not necessarily.
Is that a personal decision of the board?
Not necessarily. And understand this, because this applies to the discipline side of things as well. I can't think of anything that if it's found to be a HIB would not also be a code of conduct violation. And when it comes to discipline for students and such, it is possible. There are 2 ways to discipline. It either can be concurrent discipline or consecutive discipline, okay? Concurrent discipline, let's go into a criminal court. Someone's convicted of 2 crimes. They get a 3-year sentence for each crime. If they're served concurrently, they only serve 3 years, even though there were 2 convictions for 3. If it's served consecutively, 3 plus 3 is 6, okay? So looking to discipline for a HIB and or code of conduct violation. The HIB is going to go through this process, but the administration can discipline in the moment for the code of conduct violation. And by the time it gets up to you, because that may take a month or so, depending on when the meetings are and all that other kind of stuff. By the time it gets up to you, you may decide what's already been done is perfectly fine. That can stand, whether it was disciplined under the code of conduct or the HIB. You may say, you know what? We think the kid needs something more. Maybe they need counseling, or maybe they need to do something else. That would be a consecutive discipline. And at that point, the staff would impose whatever else is coming down. Whether or not you see a code of conduct report, if you want to, I don't see why you couldn't. Just take into account time considerations. And quite frankly, whatever you're going to receive should be consistent across the board, because you don't want to get accused of, well, why are you looking at this kid's report and not that kid's report? You need to be very careful about that kind of stuff, particularly if ultimately, now this may have nothing to do with anything, but if the kids have different protected class or from different protected classes or things along those lines, there may be an accusation, well, they only asked for the Hispanic kids reports and not the white kids reports, or things along those lines. You know, if you have a consistent across the board policy on how you're going to do it, that takes away any allegations of discrimination. If these documents are ultimately found out under court order, if litigation ensues. It's basically, as long as you have the information you need to make your determination. All of the investigation should be done before it gets to you. It's just clarification questions. That should be the follow-up.
Okay, thank you.
Okay, great. Thank you, Ms. Moore. We're now going to go to our student rep, Noah Moros.
Thank you. I just had a quick question, and I think this is referring to the slide before this. But how would students or their families report a HIB incident that happens on a social media platform with disappearing messages, such as Snapchat? Because I feel like that's where a lot of this stuff could happen. So how would a student or their family build a case against that if there's not any tangible evidence that they can bring forward?
Well, your word can be enough. If you can get a screenshot, that's great. But your word can be enough. You can put in that it was on, I forget the name of the thing where it disappears 5 seconds.
Snapchat?
Yeah. You know, your word can be enough. And what will happen is that when they do the investigation, they'll interview whoever is accused, and they'll determine which side is more likely than not the one that can be supported.
All right, cool. Thank you.
Yeah, it's unfortunately, the law in the real world is not like what you see on TV for the most part. If you watch any legal procedural, circumstantial evidence gets a really bad rap, but the majority of cases are decided by circumstantial evidence. Okay, the ones where you have a recording or a video, those are easy. Those get knocked out because you can see on your own, the camera's a neutral observer. But when it's he said, she said type of thing, it's who is more credible. And that's something the ABS is trained in evaluating who they think is more credible and why.
All right, awesome. Thank you. Just because I see that being a pattern a lot, because they think they can get away with whatever, just because it's not like there. So thank you.
Thank you. Board Member Wright, let's try again. I see your hand.
I hope you can.
We can hear you. Go
Can
ahead.
you hear me now? Oh, great. You answered one of the questions that I had as you went on. Thank you so much, Sandra. But I do have another question. What's the time frame for letters to be sent to parents about the findings of HIB, and do the board attorney have to look at it, or who has to look at it to make sure the letter is right, and what is that time frame?
There is not a mandated, you have so many days for making your decision to get it out. But what I would say is you want to do it as soon as you have a decision, because that's what starts the 90-day appeal period for appeals. And understand that appeal period is calendar days, not school days. So that includes weekends, holidays, all that kind of stuff. So you want to get, because once the statute of limitation lapses, and you'll see, I have that in a case I have in here. Once the statute of limitations for appealing is lapses, that case is dead forever. It cannot be brought up again before the courts. So you want to get that out as soon as you can, and not forget to do it, because if you, this came in under the 2018 regulations, the one that added in the ability to do the threshold assessment, because there were problems where kids would be confirmed of doing a HIB in their freshman year. And then when it comes time for them to apply to college, or like the police academy, or somewhere where disciplinary records are going to be shown, they want the HIBs expunged. So they file an appeal when the kid's a junior, even though the incident happened when the student was a freshman. So this 90-day statute of limitations eliminates that problem. And it also lets this issue be dealt with, final, done, we have a decision, we're moving on type of thing.
So does that also mean that our board attorney has to look over it and approve it, to review it, or is that done by the staff?
Not necessarily. It can be done by the staff. It's whatever you determine is the best procedure for your district to pursue. If you want your board attorney to look over each of those, that's certainly your prerogative, but it's not a legal requirement under statute.
Thank you.
Great, thank you. I don't see any questions, so please proceed, Ms. Jocks. Thanks.
Okay, so I mentioned that there was a distinguishing characteristic. There are two types of distinguishing characteristic. The first one are protected classes. These are the ones that are in discrimination law. So if all the ones at the top here are the federally protected classes. These apply in all 50 states, okay? You'll notice I have NJ Lab. This is the New Jersey law against discrimination. New Jersey has added in a few more protected classes, and you'll notice they're all the LGBTQ protections here, okay? So in the state of New Jersey is, last time I looked, it was 22. We are one of 22 states that has made LGBTQ status a protected class. So in a discrimination claim, saying, I'm Catholic, so I'll use that. Saying, I don't want to share a bathroom with that Catholic kid is exactly the same as saying, I don't want to share a bathroom with that transgender kid. It gets analyzed exactly the same way in the New Jersey courts because both are considered equal protected classes, okay? The other one here, you'll see it says hair, the Crown Act. This is a relatively new one, came about from a very unfortunate incident a couple years ago. Young man was in a wrestling tournament. The ref made him cut his hair before he could participate. So it was actually national video of this young man cutting his hair on the sidelines so he could participate in this wrestling match. By the end of that year, the Crown Act passed. So if you Google Crown Act, it'll take you right to its very short, very plain English. And basically what it's saying is looking at hair texture that's typically affiliated with minority or styles, braids, weaves, cornrows, dreadlocks, things along those lines can also be perceived as a discriminatory basis. Okay, so if that's the basis of someone being picked on is because of their hair texture or something along those lines, that would potentially be a discriminatory basis under a protected class analysis, and it's a potential discrimination claim. So anytime your distinguishing characteristic, these are usually the easier ones. Anytime your distinguishing characteristic is something on this list, that's what's called a protected class. So the affirmative action officer also needs to know about it. You don't have, at this point, something to do with that, but the anti-bullying specialist only deals with the anti-bullying Bill of Rights. The affirmative action officer deals with all the discrimination stuff. They do your equity plan, they investigate discrimination claims and such. The ABS, if it is something where your distinguishing characteristic is a protected class, the ABS has the lead in the investigation because the ABS has the 10 school day timeline to get their investigation and report done. Whereas the AAO has a reasonable amount of time. And in some districts, they implement a particular 30, 60, 90 days, but whatever it is, it's far more than the 10 school days that the ABS has. So that's why the ABS would go first, so to speak. It's also possible, if it's a really big case, the AAO might help the ABS. So what would happen is typically the ABS would notify, once it becomes aware that the distinguishing characteristic is a protected class or could be a protected class, someone from the district, whether it's the administrator or the ABS, that's for you to decide, would notify the AAO so they can open a file as well and have a AAO file on the incident as well. And remember, for their equity plan, which those are coming due this spring where they have to be revamped, they have to know all about discipline cases, people that are targeted, breakdowns of protected class status and all that kind of thing. So they need this information anyways. Those things are the protected classes. And the other one that confuses people a lot is the perceived characteristic. What do you mean by a perceived characteristic?
Hi, can I jump in 1 second? I'm sorry, because I think you might be going there right now, because one of the things I don't see here is socioeconomic status. So I don't know if that's protected or not, or if perceived or not. So just if you could add a little bit on that.
Socioeconomic status is the other characteristic. Okay, we'll get there in a second. These are the protected classes. These are the ones that are protected by discrimination laws. Okay, I'll explain perceived in a moment. I'll go here since the question led me here. We as adults have protections for these. People can't do stuff against us because we might fall into one of these categories. Okay. They can't not hire me because I'm Catholic, so to speak, or because I'm a woman, or because I'm over 40, something along those lines. The kids have additional protections. We as adults don't have this, but kids have this. And so to take the legalese out of it, if you can figure out why this kid was targeted, that's your distinguishing characteristic. And it can be something like their height, their socioeconomic status. They buy their clothes at Walmart. They're on food stamps, whatever, something along those lines. They wear glasses. They're the worst kid in gym class. They tried out for a team and didn't make it, type of thing. Their grade level or age, their clothing. So even if it's not on this list, it may be on something along these other lines. If you can figure out the why. So going back to me randomly punching that kid in the hallway, there was no reason. I would have hit whoever walked in front of me. So we didn't have a distinguishing characteristic. Let me change the scenario a little bit. Let's say in this moment that I felt like hitting someone, there was a big football player who could, with one punch would put me on the ground, or this other kid who I perceived as being weaker than the football player. So I decide to hit the weaker kid instead of the football player. Now you do have a hit because I chose the weaker kid, the weaker in stature, the weaker in strength. You pick. But it wasn't a random act. It was no, I had a choice between two and I hit this kid because. So your distinguishing characteristic is the why this kid was targeted. Now the perceived characteristic, this is one that confuses people a lot. So I'll use myself as the example. When I was in high school, I was a tomboy. I wore my hair very short. I never wore makeup or jewelry. I didn't wear skirts or dresses. I played softball. I knew more about football than most guys in the school. My family took vacations to places like Cooperstown, which is where the Baseball Hall of Fame is. For show and tell, I'd bring in my baseball card collection. It was perceived that I was gay because of how I dressed and what my interests were. I'm not. But I was called a lesbian and picked on for a while because people thought I was gay. That would be a perceived characteristic. Even though they're wrong, that's still why they targeted me, because of their misconception, what they thought. Okay, so I could still file a claim for the perceived characteristic of being gay. Now, I will say back in the 80s, I solved my problem by having my boyfriend at the time show up after a softball game. We made out in front of everyone that was there that got around the school, and then I got left alone. Okay, but in today's day and age, you shouldn't have to do something like that. Or the student shouldn't have to do something like that. Okay, they could report their perceived characteristic. Does that make sense? Okay, any questions about the distinguishing characteristic before I move on? Okay, so that's number one. You have to have a distinguishing characteristic. That's my bullying example. So then it goes into the other thing. I mentioned on one of the previous slides, it's a 24-hour day, 7 days a week, 365-day-a-year thing. And people get frustrated with that. Why do we have to deal with something that happened over the summer or on the weekend or at 11 o'clock at night? Here's the link. If whatever was said or done, wherever it was said or done, causes a substantial disruption in the school or for the student, that's the link that draws you in. So the typical scenario is, it's a movie scenario. The popular kids are throwing a party on a Saturday because their parents are out of town. They invite the teacher's pet kid that never gets invited anywhere. This poor kid shows up, and what do? They embarrass the heck out of him, and they video it, and they put it up on the internet and all that other kind of stuff. This kid does not want to come to school on Monday now because they're embarrassed because of what happened on Saturday. The fact that this child does not want to come to school on Monday, that's what links the school in. It's interfering with his ability to get his education at school. Okay? And it doesn't matter that the school had nothing to do with the planning of it, nothing to do with the running of it, didn't even know about the party until Monday morning when the kid said, I'm not coming to school because the kids are going to make fun of me. That's what pulls the school in to have to get involved and to have the legal ability to discipline a student for what they did, even though it wasn't on school grounds. So in order to have a confirmed HIB, you have to have both the distinguishing characteristic, the why the kid was targeted, and a substantial disruption, what the problem was that was caused. So you can't just say there was a substantial disruption. In your reports that come up should say, the substantial disruption was, this kid had a substantial disruption because, and then it should be explained what it is. And the law has given you 3 categories of substantial disruption to look at. And I would say this is very important as well because this also applies to free speech. So I'll get to that in a moment to show you how this all clicks together. But the three categories for substantial disruption are what a reasonable person would know. And we're looking at a reasonable, if it's a fifth grader, it's a reasonable fifth grader. It's not what you and I as an adult would think. What would a reasonable fifth grader think about this? What a reasonable person would know under these circumstances either causes them to fear or actually be harmed physically or mentally or have their property harmed physically or mentally. So the kid doesn't actually have to get punched in the face, but it can be the fear of if I walk down that hallway, they're going to punch me. That can be the substantial disruption. The kid not wanting to come to school on Monday is a substantial disruption. The kid's not wanting to ride the bus. The kid being afraid to sit beside another student in the class. Things along those lines. It's not a mere, yeah, that was stupid. I didn't like that. That is not a substantial disruption. That's a minor inconvenience. Okay, it's not one of those, yeah, stupid, but I don't care. It actually has to cause some sort of problem for this kid. So the three categories are, the first one is whether they're physically or mentally harmed or have the reasonable fear that it might happen or their property. The other, it has the effect of insulting or demeaning a student or group of students. So they're embarrassed, they're upset, they're ostracized. You know, those general icky type feelings, to take the legalese out of it, of they're upset by it. They're not able to just brush it off. It's not water off their back. This is bothering them. This is affecting their ability to concentrate in school or even wanting to go to school or participating. Or the third one creates a hostile educational environment. Anyone that knows discrimination law, we have a hostile work environment. The kids have a hostile educational environment because to the kids, school is their work. I'll give you a very stereotypical example of this. Kids are on a school bus, okay? And let's say the boys are at the back of the bus, the girls are at the front of the bus. And the boys are making lewd comments about female anatomy, okay? The girls at the front of the bus are offended by this and they don't like it. And they don't want to ride the bus every day because they know they're going to have to listen to this. And they don't want to see these boys in school and they just want to stay away from them. That would be a HIB under New Jersey law. The distinguishing characteristic would be gender. The substantial disruption is the don't want to ride the bus, don't want to be around these boys, are intimidated to be around these boys, things along those lines. And you can see the boys' defense being, well, we didn't mean to upset them. It wasn't aimed at them specifically. It doesn't have to be. Intent is not a requirement under the HIB law. So you look at the victim, a reasonable person, how would they interpret this? Well, quite frankly, the boys should have known they were being loud enough to be overheard. It's reasonable for a 8th grade boy to think if they're joking and laughing loudly, they're going to be overheard by the other people on the bus. Okay. It's reasonable if people are going on and on about female anatomy. People are going to be offended by that, maybe a little even intimidated by it. Okay. Now, where the district has the flexibility will come on the discipline side of things. So let's say, yes, we do have a confirmed HIB. Your distinguishing characteristic is gender. Your substantial disruption is the intimidation of the girls at the front of the bus. If these kids had never been in trouble before and they truly had no clue that they were causing a problem, the discipline may be a talking to or some sort of sensitivity discussion. If, however, it's the 5th time they've been told the same thing, well, it's going to be a higher discipline then. Or if they're a special ed student, then there'll be a manifestation determination done to figure out is what they were doing a manifestation of their disability as described in their IEP. But the discipline, what the ultimate discipline is going to be, or may or may not be, has nothing to do with the determination. Is it a HIB or is it not a HIB? That was another thing that came out under the amendments in 2018. There was a misconception, particularly among a lot of parents of special ed students, that a classified student could never be found to have committed a HIB. And that is not true. They can. The difference is in how you deal with the discipline side. If someone is a special ed student, then there is a manifestation determination done to see if whatever they did was a manifestation of their identified disability. If it is, then you go down one road for dealing with them in discipline. Maybe it's a modification of the IEP. Maybe it's something else that's set out, but that'll be something with the special ed team and the whole bit. But if what the child did is not a manifestation of their disability, then they're disciplined the same way a gen ed kid would be. Okay. You know, taking me, hitting the kid in the hallway. Let's say my disability is I have difficulty reading and there's some documentation, some reason that I am slow reading tests. That has nothing to do with why I punched a kid in the hallway. So my punching a kid would not be a manifestation of my reading disorder. Let's change it. Let's say my disability is that I have an anger management type of disability. And I'm not an expert in, you know, all those types of things, but generally, let's say my disability is an anger management issue. Well, it is reasonable, it's possible that my hitting a kid is a manifestation of my anger management disorder. And so it would be treated differently. Okay, I just gave you a whole lot of legalese there. Does all that make sense? Are you with me? I don't hear any no's, so I'm going to take that as a yes.
Yes, you can keep going. Thank you.
Okay, so it'll be one of these three things to show that there was a problem caused for the student. If you don't have a distinguishing characteristic and or don't have a substantial disruption, you do not have a HIB. And remember, as I said, as the board, you're answering two different questions. Is it a HIB? And then was the discipline appropriate when you're reviewing these claims? Okay. So I've given you a couple of cases here, and you can see they're pretty recent cases. I've also, these links should take you right to the case. If for some reason they don't, they're all easy to find. They're all on the Department of Ed website. If you go to njdoe.gov, go to the A to Z directory, click on L for legal decisions, and then there's a drop-down menu. You can get commissioner decisions, and that's where all of these are. And you can read the full decision in its entirety rather than just my summary on the slide. Okay. So in this particular case, you had a young man was with a girl at a Halloween party off of school grounds. And there's no dispute that he did something where he put his hand on her. The dispute was how he did it. The female student claims she grabbed him, he grabbed her buttocks, and the male student said, well, I did touch her, but it was just a poke. It wasn't a grab kind of thing. I was just fooling around. So there was a HIB claim filed. Even though this was off of school grounds, these two were in school together, and this affected the alleged victim in school. When they did the investigation, it was determined that the distinguishing characteristic was gender. This would be a sexual harassment claim. And a substantial disruption was that she feared being in this young man's presence and that there was a history of this type of improper behavior. So they could substantiate what it was. Now, do understand when I mention history, just because they were bad before doesn't mean they're bad this time. Just because someone's always been good doesn't mean they didn't do something wrong this time. What you'll look at the history for is, let's say someone says, I didn't know that was a problem for this kid. And then you look, well, you've already gotten in trouble for it 4 times. It doesn't prove you did it this time, but it proves you should have known by now not to do what you just did. Okay, so if they're claiming, I had no idea, that shoots their credibility because you got in trouble for it 4 times before. So yeah, you did have an idea. So that's a reason not to believe that kid with whatever they told you. So in this one, your distinguishing characteristic was gender, an improper touching, sexual harassment, and the substantial disruption was she was afraid of him. She was afraid to be around him when they were in school. School determined that it was HIB. The ALJ and the commissioner determined that it was HIB. When it was done, the male student filed a discrimination claim, which summary judgment motion was granted, means it was thrown out. But the court said, no, they followed their HIB process properly. I see a hand up.
Go ahead, Ms. Moore.
Hi, I just have a question. I just want clarification, Sandra. For a special ed kid, are you saying that we should do a manifestation determination first to make sure that their actions are not part of their disability that caused them to be part of the HIB before we proceed with the disciplinary part of the HIB?
With the disciplinary part only, yes.
For the disciplinary part HIB. So does that pause the investigation?
Oh. No, and you'd probably be doing that anyways, just on a code of conduct basis, because how you discipline a student depends. If they're a classified student, you have to look and see if whatever they did was a manifestation of their disability. Now, barring the exceptions, they brought a weapon to school, they physically assaulted student and that list of exceptions there, if it looks into, or if, let's say, they're going to be out more than 10 days, it's another misconception. You can't suspend a special ed student longer than 10 days. You can, but in order to do so, you have to have a manifestation determination to see if it's warranted, because they want to avoid those students when they're suspended, they're not in the least restrictive environment and they're missing out on school. So you want to make sure you're not dealing, violating FAPE and all that kind of stuff. But whether or not they're special ed has nothing to do with determining, is it a HIB or is it not?
Okay.
The determination, the reason for a classified student that you're going to look at the IEP is determining discipline.
Okay. But we've also, just so you know, we've taken the position that we want the case manager in from the very beginning. In other words, we want them to be part of the process when it comes to investigating the HIB.
Well, they can be, and they're going to be the ones working, but they may give perspective to the ABS
Okay.
About why things were done. And it's so messy because there are never black and white answers, and that frustrates people. The famous lawyer answer is, well, it depends. And people hate that answer. But
can you repeat that?
I said the famous lawyer answer to a lot of questions are, well, it depends. And people hate that answer because they want a yes or no to everything. And unfortunately, a lot of stuff is very fact driven. So again, there can't be the misconception that just because they're classified, it can't be a HIB. And part of it, there have been instances, someone can make a negative comment. Let's say I have hazel eyes, so I'll use me. Someone says to me, I hate people with hazel eyes. For some kids, they're going to go, yeah, I don't care. Other kids are going to be highly offended and upset by it. The kid that says, yeah, I don't care, there's no substantial disruption. The kid that's highly offended and upset by it, there may be a substantial disruption. So you're going to have to look to the victim. So if you have a kid, a classified student, and this is on the personnel, if you have a classified student that because of their disability, they tend to do something. Maybe they swear at people or they do something that's just out of line, that people can be offended by if they don't know what's going on with this child. It's on the school to help people understand, not necessarily disclosing the specifics of the child's disability, but just helping the community understand of, John doesn't mean anything by this or something like this, where some kids won't be offended by it. But the special ed people cannot say to the ABS, no, that's not a HIB and you can't find it not to be a HIB. They can't do that. The ABS is the final decision maker.
Okay.
And intent is not an element or a requirement. It goes going to my boys in the back of the school bus type of example, where their real big impact is going to be, will be on the discipline side and what's done, regardless of whether it's a HIB finding or not. If the kid did something, what's done in the aftermath. And quite frankly, and sometimes this is the problem, the same thing is happening 5, 6, 7 times. Well, if it's happening 5, 6, 7 times, that means the IP wasn't adjusted properly. If you're having the same thing happen over and over and over and over again, you need to change the circumstances of the student so that they're not in that situation over and over and over and over again, or to the best of your ability to deal with it. Does that answer your question?
It does. And I just had a follow-up question, just a clarification. When it comes to notification, we have 5 days to notify the parents, right, in writing of the outcome.
That's a district policy of the 5 days. It's not a state requirement, but it's a district policy. The other notification issue, and this gets sticky sometimes, and this is where you get a lot of kerfluffle with parents, so to speak, is you don't need the parent's permission to talk to the child. Okay, you are in local parenti. You have the obligation of protecting the safety of the school.
Can you blow that up for us and on a billboard and put it outside our school district for us?
The best practice from the district perspective is to be interviewing the child while the parent is being notified.
Thank you. We're gonna have you put that on your car and just drive in front of the schools for us. Thank you.
Okay, because you don't want the student tainted by what's.
Thank you.
And You know, and it's problematic. And now from the parent's perspective, I could understand, what do you mean you can talk to my kid without me knowing about it? Well, they talk to your kid all the time, but they have a student safety issue. And this comes into play once you notify the parent. If the parent shows up at the school, you can't send them, to the pool on the roof. You have to reunite them with their child. But if you get the poor kid in the situation where he's sitting there and he's going, my mom said I can't talk to you. That's what should be written in the report, is the child did not answer questions because his mother told him not to, or his father told him not to. Unfortunately, what will probably happen in that situation is you won't get that kid's side of the story.
Right.
So when you get the finding against that child and the parent goes, how could you do that? Well, you wouldn't let him talk to me. So I don't know what his side of the story is. It seems more likely than not, based on the evidence I have of what the accuser said. And a lot of times then it gets okay, we have to work together on this to get to the bottom of it. And a lot of times, I mean, looking at this from a reasonable perspective, I firmly go to that just because someone's accused doesn't mean it's true. Both sides are entitled to legal due process. Both sides are entitled to have fairness attributed to them. But, when you got one story that's way over to the left and one story that's way over to the right, the truth is usually somewhere in the middle. Okay. But if the ABS is not allowed to gather the facts in the investigation, they're only going to know what they know. They can only base their decision on the evidence they have. So if you withhold the evidence, they're just going to be judging, is what the other person said believable or not? And if it is, it's going to be a positive HIB finding. This is not criminal court where it's beyond a reasonable doubt. This is civil things. This is the more likely than not. Does something tip that scale ever so much? And this goes back to the same thing I said at the very beginning. When you have that true situation of, I really don't know. I just really don't know. Then they should find in favor of the accused. I'll give you an example of a real case. There was a child in the lunchroom at a table claimed that the student sitting across from her said, I'm not going to share my cookies with you because cookies will make you fatter than you are. Okay. And the alleged victim reported this. So before we do the analysis, the distinguishing characteristic would be weight. That would be her distinguishing characteristic. The substantial disruption, she reported that she was embarrassed and upset by the comment. So that would be your substantial disruption. Okay. When the ABS did the investigation, the accuser said, this is what happened. The accused said, I never said that. That's not true. It didn't happen at all. And the other two kids that were at the table said, we didn't hear the conversation. We didn't hear anything about that. We have no idea. And so the ABS went, I don't know who to believe. Both sides are believable. So she found in favor of the accused. The parent appealed that decision, and the district's determination of not being a HIB was affirmed because it was reasonable. There's no other evidence, both one saying yes, one saying no, and there's nothing to tip the scales. It's not preponderance of the evidence. It's not something that's more likely than not. Okay, I'm adamant about protecting both sides, and that's also the difference between a court or a legal analysis and the court of public opinion. In the court of public opinion, someone says something, bang, you instantaneously make your decision whether you like them or not, whether you believe them or not, what you think. In a legal analysis, you don't do that. That's why this process takes so darn long. Person A says this, person B says that. We neither believe or disbelieve either of them. We just have two people with two different versions of a story. You do the investigation, you get all your facts, and then once you have all your facts, you decide who you believe. That's the point of this ABS process.
Sandra, I have one last question before you move on.
Sure.
Because that's such an important point, and it speaks to really the meat of this work from the perspective of just trying to keep all of our kids safe and happy and feeling like they're supported in our school district. But I guess one of the most important questions, right? If I'm the ABS and I've determined that both of these kids are believable and there's just not enough evidence to sway me one way or the other, as you stated, I'm in the middle. So the middle goes to the student who was accused. And so when that rises up and that is not that's not determined to be an HIB, at what point, I guess, we all are people and we have different perspectives. As the superintendent, if I receive the ABS's report and the ABS says that they are not swayed by the arguments, at what point, how much power does their view over that have, I guess, in this process of moving it forward through our district? Because I could have a difference of opinion of that ABS, or the board could have a different perspective of what that ABS has passed through me. So just wanted to kind of get your perspective on that quickly.
If as the superintendent, you disagree with the ABS's finding, you can certainly write your own version saying, I disagree, and here's my basis for my opinion, and then the Board of Ed is the tiebreaker. Now, it is also possible, it's not required, but it is possible, if it's somehow possible that the ABS gets their report done early, that the administrator or the superintendent can say, can I see what you found before it's officially filed? Can I see what you found? And that's a chance to ask clarification questions, or maybe have them add something to the report or go back and look. Now, understand the superintendent cannot say, I disagree, you need to change your report. It's the ABS's name at the bottom of the report. They submit what they found. But if there's time, there's not always time, depending on how things work, but if there's time, it is permissible for the superintendent or an administrator to say, can you explain why you thought this person was more believable than that person? They should be able to do that. And that's actually, that's part of what I'm going to be doing when I train your staff in February about how you determine who's credible and who's not, and things along those lines. You are not going to be interviewing all of the witnesses. That's what the ABS did. Okay, so if you've got a kid who is just, I'll make up an example here. Okay, let's say the allegation is that there was in the gymnasium, a kid overheard another kid making fun of their weight. Okay, well, when the ABS goes to the gymnasium, where the victim was standing was in the far corner by the girls' locker room, and where the alleged perpetrator was is on the other complete opposite end of the gym near the boys' locker room. And this was during fourth period gym when there were seventh graders playing basketball in between those two spots. Well, from a legitimate standpoint, it'd be impossible to hear the kid by the boys' locker room whispering some comment about the kid's weight that's over by locker room A, where the girls are. So that would be a reason not to find credit.
It's an authentic process where everyone is feeling heard and everything is legitimate and no one is feeling that kind of pressure from a professional standpoint. So I appreciate you verifying that, not just for me, but for everyone who's watching as well.
I mean, the bottom line is you want to do what's right, and you want to do what's fair and reasonable, and you want to get to the point. Part of the problem is law and education are look at things two different ways. Okay, in education, you're nurturing. You want to help everyone. You want to see everyone succeed. You look for the best in everyone. From a legal perspective, we usually assume everyone does the wrong thing. We're cynical, and there's a different approach in how you deal with things. In the education setting, you don't necessarily care who did what to whom. You just want to resolve the situation as a whole and make the community better. From a legal perspective, you can't get to the resolution until you determine who did what to who. So, and unfortunately, you as educators are being asked to basically be little judges, pseudo judges, without the benefit of a law school training and passing a bar exam. So that's what you're doing on that level. I see a hand up.
Yep, go ahead, Board Member Malesena.
Yes. So, getting sort of back to what Dr. Taylor was talking about, how do we make sure that ABSs are not feeling pressured to change their reports? Because my concern is at times I'm in a school myself, so like I have a better understanding of these, like how the dynamics work. That at times ABSs might feel pressure or get pressure from administrators or others to change the reports to a certain way. How do we as a board deal with something like that? Or how do we make sure that that's not happening?
Part of it is an ethics issue. there should be a procedure that if you are going to use this process, if the superintendent or the administrator is going to use this process of, hey, can I see your report before you formally submit it, that it's known how this is done. And I would suggest, again, like I mentioned earlier, it not just be this one random case that they're looking into, it's just looking to get things right. The other thing which may help is another thing that came out of the 2018 amendments is that an ABS cannot investigate someone in their own bargaining unit, or under labor law, they can't investigate their boss. So if the adult accused of a HIB is in the same collective bargaining unit, and that's possible since a lot of the ABSs are counselors, and a lot of times the counselors are in the same collective bargaining unit or union as the teachers and others in the school. In that event, under state law, someone that is not in that collective bargaining unit must do the investigation and reach the determinations. So whether it's a VP or a principal or someone along those lines. And under straight labor law, you don't investigate your boss. So if you're a counselor that's the ABS and it's a vice principal or a principal or the superintendent that's accused of the HIB, you're not doing that investigation. It has to be someone equal to or above the rank of whoever is accused, so that you can't have that they're influencing me. It'd be one of those, I know you're giving me my evaluation next week, but I have to find out whether you did a HIB or not. That just would not work. That's a true conflict of interest in dealing with these things. Beyond that, it's one of the, as I would say, the biggest preemptor of that is just having a process in place that it's known to all the buildings in your district. There have been problems with some districts, particularly larger districts, where left hand doesn't know what the right hand's doing. So maybe in schools 1, 2, and 3 they do it this way, but in 4, 5, and 6 they do it a different way. You're all in the same district. You're all supposed to be doing it the same way. The procedure is the procedure. The Board of Ed policy is the Board of Ed policy. It applies the same. So it's not the happiest answer I can give you. It's not like you can sit in and listen to any of these conversations between everyone. But that is the best I can offer you, is understand the conflict of interest issues that come out from the 2018 amendments, and having a process of how you're going to do this, if you're going to do it at all, or you're going to allow a preview, so to speak, if time permits, of any of those decisions. And again, I go back to whatever they're asking for, they should be comfortable putting it down on paper of what they need a clarification of. So it's not just one of those, well, I don't like the way you did that, do it again. Could you put that on paper and think it'd pass muster in front of a judge? No, I wouldn't think so. You have to be able to explain what's missing. I don't understand this.
Like our process, if I'm right, and please somebody correct me if I'm wrong, is that like we have an ABS person in each building, they do it, then it goes to the principals, then it goes to the superintendent and so forth. So if, say, a principal doesn't.
You mean the report?
Right, the report, like the final print, thing, if there's, like a concern that
the ABS wins.
ABS is saying this, but then the principal looks at the report and is like, nope, that's not it, then
the ABS wins. Let me tell you the way the game is played. If during your threshold assessment, which your district has that policy, it's the one me punching the kid in the hallway, and the principal goes to the ABS, I think this is code of conduct, we don't have a distinguishing characteristic. And for some reason, the ABS disagrees, the principal's opinion wins in that situation because it has not officially been turned over to the ABS to investigate. Once the principal turns it over, or the vice principal, whoever's assigned as the administrator, turns it over to the ABS's decision rules. So if the principal and the ABS disagree, it's the ABS who wins.
Okay, that's helpful. Thank you.
Great. Thank you.
Okay. All right. Let me, 1 second. I expanded all the pictures so I could see all of you. Okay. So going back to this one, the Halloween party, it was legitimate for the district to get involved with this. Another case, this involved a teacher. Teacher supposedly said to an overweight student who was walking slowly, if there was a cupcake up there, you would move faster. And then other food-related comments. The student reported this to the administration. They did the investigation. and they determined that it was a HIB. Your distinguishing characteristic is weight. Now, that's not a protected class. That's not something the affirmative action officer needs to know about, but it is one of those other kind of characteristics. So the distinguishing characteristic was weight. Substantial disruption was she was bothered by it. It interfered with her. She was uncomfortable being in this teacher's class. The teacher tried to defend herself, saying, well, I have a good relationship with them, and I didn't realize she might be offended by it. I didn't mean anything by it. And she also had an allegation that her due process was violated because she wasn't personally allowed to interview the witnesses that the ABS interviewed. The district found that it was a HIB. She appealed. And her discipline, mind you, was a letter of reprimand and sensitivity training. That's what was imposed against her. What was ultimately held was that this was a HIB. She was not entitled to cross-examine witnesses. Now, this is from case law here. She wasn't entitled to cross-examine witnesses. That's the ABS's function. And that her due process rights were not violated. It was more likely than not, the credibility determinations were, you had your distinguishing characteristic, you had your substantial disruption, it's a HIB. And I will tell you, in the majority of the cases that I have read, the courts side with the district and what their findings are. The ones where they don't are where the reports are not clearly identifying, you know, in bright fluorescent, here's our distinguishing characteristic, here's our substantial disruption. If one of those two things is missing, that's when they get remanded and sent back. Okay. It did go to OAL for the discipline issue, but as far as it being a confirmed HIB, that stood, because that's a grievance issue and all that other kind of stuff dealing with what you're allowed to discipline under the collective bargaining agreement. Okay. Another case, parent accused a coach, and unfortunately there are a lot of coach cases. You're not playing my kid got cut from varsity, all that kind of stuff. You bullied my kid when you cut him from varsity, that kind of thing. In this situation, parent accused a soccer coach of bullying her son because of his commitment to academics. The HIB, the ABS found no HIB violation. They said that there was no distinguishing characteristic in this case. The coach had apparently made one of those comments of, you got to keep your grades up to the entire team, as opposed to just one kid. And so the parents said, well, the distinguishing characteristic should be his commitment to academics, and because he's a student, that student status should be his distinguishing characteristic. And when this got to appeal, the court said no. Just merely being teacher-student is not a distinguishing characteristic. You have to show what the teacher did that caused the problem. So going back to the earlier case, the fact that the teacher making the comment about cupcakes, just because she was the teacher and the victim was the student, that's not your distinguishing characteristic. Your distinguishing characteristic is she made fun of her weight. The weight is the distinguishing characteristic. Okay? And again, this does go to showing you have to have both. The kid may have very well been upset by whatever the coach said about academics, but there was nothing singling this kid out. There was no distinguishing characteristic here. All right, another one. Online exchange between a group of fifth grade girls, and it used a lot of vulgar language. And one student who was Black was called the N-word by another of her friends in the group. Well, the girl in the group of friends didn't care, but mom found out about it and mom cared. And mom called this into the school and said, my kid was bullied. So when they investigated this, the distinguishing characteristic would be race if it was determined to be a HIB, you know, using the N-word. And that is a protected class, so it's something the affirmative action officer should also know about. When they talked to all of the girls involved, including the alleged victim, they all said, no, that's how we talk to each other. We were pranking each other. We were fooling around. There was no substantial disruption. Did you have your distinguishing characteristic? Yeah, but the alleged victim didn't care. So there was no substantial disruption, so it is not a HIB. Now, if this happened on school grounds, it would be a code of conduct violation because you can't swear or use that language in school. But since the kid wasn't bothered by it in any way, no substantial disruption. And the parent had tried to argue that the use of the N-word should be an automatic finding of HIB, and the court said, no, we can't go there. There are elements. You have to have 1 and 1 must equal 2. You have to have the distinguishing characteristic and the substantial disruption in order to have a HIB. And this is, unfortunately, a lot of people don't understand the legal definition versus the generic everyday use of the word bullying. That's what causes a lot of this problem. Okay. Another case. This goes to the appeal where a student was accused of saying to another student that they were a poor African. Ultimately, it's determined that there was a HIB. Now, the board's written decision went out on March 6th of 2020, but they did not appeal it until June 29th of 2020. And what happened was it was thrown out of court because it was barred by the 90-day appeal period. So this is what I was going to about the importance of making sure whatever your decision is, you have it in writing and you get it out, because that's what starts that 90-day appeal period. If they miss that, it's gone. And in this case, they tried to say, well, because of the COVID stuff, we were delayed. And the court said, no, that COVID stuff is not an explanation for the delay in this. You had 90 days, you missed the 90-day period. Okay. All right. So just a summary of the requirements. The legal elements, you need a distinguishing characteristic. It can be a protected class or the other, you know, the height, the grade, the teacher's pet status, the socioeconomic status. And then you need a substantial disruption, which can fall under one of three categories or multiple of these. It can be 1, 2, or 3 of these things. The actual or reasonable fear of physical or emotional harm to person or property, it's insulting or demeaning, or it creates a hostile educational environment. Things to remember, it's a 24/7 policy. This includes the cyberbullying stuff and hybrid teaching. There have been a couple of cases where staff have gotten in trouble because when you're hybrid teaching, they say inappropriate things, or some of them they put stuff in the chat. So there was actually written evidence, because all those chats are preserved. There was actually written evidence of what they may have said to someone. It's a problem. Remember, there's a duty report. Your staff has an obligation to report. The district must investigate all reports or look into them, even the anonymous ones. Now, I understand that sometimes it's really way too vague. You'll get there's a problem with bullying in the 5th grade. Well, thank you. What do I do with that? What I would say is, as long as there's something maybe where there's a discussion with the teachers, have you noticed any problems with bullying in your class? 3 weeks later, when you get something saying, look, I reported this problem 3 weeks ago and now an incident has happened, you will have the fallback of, we looked into what you reported, but there was insufficient evidence to do anything. We seriously looked at it, but there was nothing there. Now that you've given us more information, now there's something we can do about it. Okay. And let's see, privacy rights. Don't forget your FERPA and New Jersey Pupils Act information. You know, you can't disclose what you learn about all this stuff. If you only know about it because you work for the school, you can only talk about it with school people. Basically, that's what it is. Special ed considerations, we already covered those, and that this only protects the students. It does not protect the staff. Okay, any questions about that? I just want to do a quick thing on free speech. Most common offense.
Yeah, we have a couple questions. Let's go to Board Member Valamani and then Board Member Telesford.
So I have a question about when an event becomes a HIB. Is it sufficient for it to have happened only once, or do you need to have a pattern for it to happen?
No, it only has to happen once.
Okay, thanks.
By randomly punching the kid in the hallway, that was a one-time thing, that could be a HIB.
Thank you. Board Member Telesford.
Yes, I have a question about, so in the last case, you talked about how a parent saw some messages that students were exchanging and the students didn't have a problem with it, and so it was not considered a HIB. Let's just say that for some reason, another student or students in the school found or saw like screenshots of this conversation and this bothered them because of the language. Would then that be considered a HIB?
It could be. It will go to the reasonableness of it. I will give you a real case example where all the students involved were Black, but there was a group that they were all talking to each other and they were using the N-word amongst each other. And another child overheard this. Again, they're all the same race, overheard this, but was not part of this group. And this kid was bothered by this and upset by it and didn't want to be around it and went and reported it. And the defense, so the distinguishing characteristic is still race. Even though they're of the same ethnicity, the distinguishing characteristic can still be race, okay? And the substantial disruption was he was embarrassed, he was upset, he didn't want to be in the class with them, he considered it a hostile educational environment. So in looking at it, was it reasonable for anyone else in the room to overhear this conversation? Sure it was. And even the kids at that age should know if you're going to be loud and joking around, people are going to hear this. The defense of the young man that used the word said, no, there was no intent here. And see, I was using the A ending of the word. That's the familial where we're fooling around. If I had used the ER ending of the word, that would have meant I was being, mean to him. And the school and ultimately the court said, no matter which ending you put on the word, it's inappropriate. It's reasonable for this child to have been upset by it. So that is a HIB. Now, going to the discipline, if you talk to these kids and they truly had no clue that they were doing something wrong or inappropriate, the discipline may be a talking to or maybe an apology to the kid that they said it to. If, however, this is an ongoing persistent problem, it's just like with staff with progressive discipline. The more they do, and all this will be documented, of course, if this is the 20th time they've had this problem, part of it, you would look to the climate and culture. This would be something your school safety team would be looking at as well, in looking at this. Why do they feel that they can do this in the school? And, how do we get them to change the error of their ways? I don't care what you do when you're outside of school on your own time, hanging out in the basement playing video games. You can't do that in this building. It's just like you can't do this when you go to work, and you can't do this in particular places, that type of thing. Does that answer your question?
Yes, thank you.
Sure.
No, I don't see any other questions.
All right, so just quickly, because the last question does touch on the free speech stuff. So I'll give you the quick background of that, because that is one of the most common defenses of I can say whatever I want and you can't touch me for it, which is not true. So the thing to remember is, one of the required elements of a HIB is a substantial disruption. Well, there are two cases that apply. The students have what's called the Tinker case. This is where the kids wanted to wear the black armbands to protest the Vietnam War. The school found out about it, passed a rule saying you can't do that, then suspended the kids that did. They took it to the Supreme Court, and the Supreme Court found in their favor. The staff have a case called Pickering. Pickering was a teacher who lived in the town where he worked. He found out how the school was going to spend money by attending a public town meeting, wrote a letter to the editor of the paper complaining about it, and the school fired him for it. He filed a lawsuit claiming they violated his First Amendment rights, and the Supreme Court agreed with Mr. Pickering and said the district was wrong. In both of those cases, what they said was the district has to show that whatever was said or done, wherever it was said or done, causes a substantial disruption in order for the district or employer to have the power to discipline or tell you, knock it off, don't do that anymore. So think about it. If you have a confirmed HIB, that means you have determined a distinguishing characteristic and a substantial disruption, which is another reason why you have to have it articulated. Here is what our substantial disruption was, because a positive finding of a substantial disruption nullifies a free speech defense. Okay, so going through it just quickly, and I've given you the site to the case. If you want to read the cases yourself, if you Google what I put up here in the title, you can read the whole case if you want to. That's where the case is. For students, they have more free speech rights than staff do. That's the common lament of, that's not fair. The kids can say more than I can. You're right. They can accept it, deal with it, move on. It's not changing. Okay. The kids in a lot of situations have more rights than adults do. That is the way it is under the law. So it's very broad. What the kids cannot do is they can't do threats of violence in many forms, things along those. You can't promote illegal drugs. The Bong Hits for Jesus, kind of a neat case. Remember with the Olympic torches, they would run through all the countries that are participating in the Olympics. This was up in Alaska where the torch was scheduled to run in front of the school. And so these kids stayed out of school that day and they unfurled a banner that said Bong Hits for Jesus right in front of the school. And the administrator went out and took it down. And then they sued, claiming a violation of the free speech rights. And the U.S. Supreme Court agreed with the district. And they said, look, a district cannot promote illegal drugs. So this cannot fly. And just to preempt recreational marijuana has been passed in New Jersey. Yeah, but it's still illegal to do it if you're under 21. So all the students in your school still can't do it for a recreational purpose. So it's the same thing as alcohol type of thing. Lewd and vulgar language. The Bethel case was a young man, I think it was, running for a student government position. And at his speech to the school population, his speech was laden with sexual innuendos and all kinds of sexual references, and they suspended him for it. He filed a lawsuit and he lost, claiming it was a violation of his free speech. The Dunkley case was a New Jersey case, the New Jersey Supreme Court decided, where a young man, while he was at home on his own computer, used it using a couple of platforms to make fun of a classmate, making fun of her teeth. If I remember correctly, he said her teeth were like a can opener or something like that. And she was very upset by it. So doing the HIB analysis, the distinguishing characteristic is her physical appearance or her teeth. The substantial disruption is she was embarrassed and she was upset by it. Check and check, you have a HIB. And he tried to say, can't touch me off school grounds on my own computer on my own time. And the court said, yes, they can. Because what you did off school grounds on your own time caused a problem in the school, caused your substantial disruption. See how all that ties together? And really the importance of articulating what your disruption is. So this case was in the news quite a bit. This is the cheerleader case where she didn't make the varsity team and she was very upset by it. So she put out on Snapchat a picture of her giving the middle finger and saying F school, F softball, F cheer, F everything. And then she circulated among 250 quote unquote friends. Ultimately, it got back to the coach of the cheerleading squad and they suspended her from cheerleading for the year. She appealed saying that you shouldn't do that. And the school said, nope, we're going to do that. So she filed a lawsuit claiming a violation of her free speech rights. Ultimately, what happened was it was determined that the school had violated her free speech rights in that they didn't show a substantial disruption occurred. Okay. When they looked at this, they said because the school did not show what substantial disruption there was or give anything that indicates a substantial disruption off of school grounds, the kids have the right to vent. And as long as whatever they're saying or doing is not, where is it? Something along these categories about what's not protected, they can do it. But in this particular case, the only thing that had happened was there was a discussion by a few students here and there at the beginning of the class, but that was it. It didn't interfere with anything else. Now, change the facts a little bit. If she had said this while in the school building, that would have been a code of conduct violation because you can't use that kind of language in the school building. So she could have been disciplined if she had said it on school grounds. But off of school grounds, she has the right to vent. Okay, as long as it's not threatening or harassing or causes a substantial disruption. See how this all ties together? And a lot of people misinterpreted this because they only caught the soundbite on the news where it said the school was in the wrong for disciplining this student. And so they have the opinion of, well, my kid can say whatever they want when they're off school grounds. You can't touch them. That is not true. If the district can show whatever was said or done, wherever it was said or done, caused a problem for the operation of school or negatively affected someone in the school, the district has the right to intervene and potentially impose discipline. Okay. So the Supreme Court went on to list some specific things that they talked about where the school would be able to discipline for off-campus speech. So those are there for you. I will bring up too the potential penalties. A lot of kids think they can get away with, well, I'm a kid, I was fooling around, where they call in a bomb threat or a shooter threat or something along those lines. That can be a felony, which can land them in jail and get them arrested. And the defense of I was fooling around does not fly with the police department. So an example of a case where arrests were made, earlier this year, 3 kids posted nude pictures on Instagram. Here are all the things that they were charged with, of fellow students. And I've given you a link to the article if you want to read the article for yourself. Okay, so just for the staff to, make kids, you can't fool around with this. You got to be careful about this stuff. Going to the staff, I told you the story of Mr. Pickering. The Supreme Court came out with 3 questions to ask in those situations. The first is, did the statement, and mind you, Pickering is the standard that applies to you as board members as well. Once you are on the board, you are now a district agent. What you could say before you're on the board is very different from what you can say once you're on the board. You don't have the same freedom of speech that you had prior to being on the board and expect to be able to hold your position on the board and not have an ethics violation or otherwise be cast off the board. So you need to be careful about what you say. So there are 3 questions to ask about whatever is said or done, wherever it's said or done. Did the statement concern a matter of general public concern? Was the employee speaking as a private citizen or during their duties? And did it disrupt a working relationship? See the disrupt, my favorite word, substantial disruption. So I'll use that as an example, COVID. Okay, is COVID a matter of general public concern? Yeah, it is. Was the employee speaking as a private citizen or during the course of his duties? Well, if you say it in a board meeting or in the school, it's pretty clear it's going to be taken of as a board member. I would caution people to be careful, though. A lot of people on their Facebook or whatever their internet sites are, they list themselves as so-and-so at this school district. It can be argued that if you've listed your ID on that social networking platform as an employee of the district, everything you say or do on that platform can be affiliated with you as an employee of the district. So it's in your best interest to not do that. It's a suggestion, it's a best practice. It's not a requirement, just a best practice. But let's say you're saying something, you're a parent as well. And so you make some comment somewhere of, I think these mask mandates are crazy. I think the district's crazy for making kids do that or something like that. Okay, fine. And you're going to claim you said it as a parent. Well, then we get to, was the statement likely to disrupt a close working relationship? If unfortunately someone has recorded you saying that or has got you, what's going to happen is that's going to become something that's circulated all over the place of board member or administrator or teacher says mask policies are stupid. And now you're going to cause problems for the school, which will cause a disruption. So even though you got the first two that are okay, if you lose on the third one, this is the big one, you can be asked to stop doing that, or depending on what it was, be disciplined for doing it. This is the same, this applies to all staff. This is the staff standard. And the way that they look into analyzing, was there substantial disruption? These are straight out of the Pickering case, actually giving you the page numbers they come from. Does whatever you said or did interfere with the classroom or the school function, the working relationship between the school and the people involved? So this is basically, you can't bash the school and you can't bash the employees, okay? Or you can't speak in a manner that's in reckless disregard for the truth, creates a problem, undermines the supervisor's discipline, or this is the big one, compromises the loyalty and confidence. If you only know about it because you work for the district, you can only talk about it with the relevant district people. You can't go home and tell your spouse, oh my God, you're not going to believe what I heard about today. Technically, if that gets found out that you had that conversation, you have violated the free speech requirement. Okay, with the students, that would be protected under FERPA and the New Jersey Pupils Act. With staff, that would be an HR privacy issue. Okay, and you are opening yourself, if it's a staff member and you talk about what you know about pertaining to their employment outside of the realm of being a board member with your fellow board members, it's a potential basis for a retaliation lawsuit or a discrimination lawsuit. So you need to be very careful with it. That's why a lot of times when you see on the news, it sounds horrible, where a school district is accused of doing something. And the person accusing lists this litany of stuff, 10 pages worth of stuff in the complaint. And the response all the time is, we don't comment on ongoing litigation. Now that makes the district or the business look terrible. But legally, that is all they can say. And trust me, as someone who always represented the side that was accused, they are dying to tell you everything that they know about the accuser. But legally, they can't, because it's potentially opening up for a retaliation claim or some violation of privacy issues. So that's why you hear those, we don't comment on ongoing litigation. It's frustrating, it's aggravating, and of course, ultimately, if it's found in favor of the district, that's on like page 50 of a 50-page newspaper. But that is the way that it works. Okay, so with that, that is the end of my presentation. I'll just get through this. There's the link to our other content. You will, when you get this PowerPoint, there's this survey. It's a quick, what did you like? What else would you like to learn about kind of thing. I think it's 4 questions. And then you get your PD certificate for listening to me talk this evening. Okay, so that is there for you there. Is there anything I can answer? Any questions? Anything?
I don't see any hands, so thank you very much for coming virtually this evening. Stay safe and be well. Thank you again.
Thank you. Have a good night. Happy New Year, everyone.
Happy New Year. All right, we'll now move on to the action portion of the meeting. like to make a motion to move resolutions 4242 and 4243 for discussion. May I have a second?
Second.
Thank you, Board Member Siders. All in favor?
Aye.
All right. That appears to be unanimous. Mr. Burnside? All right. Any discussion on items 4242 and 4243? Hi. Excuse me. Sorry. Board Member Malesena.
Hi, yes. I have concerns about the items. To appoint people to positions, it would have been nice to have been asked instead of told.
I'm sorry. Can you just repeat that? We lost you. You went in and out.
Said, while I understand that the board president has the right to appoint people to positions, it would have been nice to have been asked instead of told.
All right. Thank you for that. Any other questions or feedback? All right, seeing none, close discussion. Mr. Burnside, can you please call the roll on items 4242 and 4243?
Board Member Bergen,
Yes.
Board President Joshua,
Yes.
Board Member Malesena,
No.
Board Member Siders,
Yes.
Board Member Telesford,
We didn't hear you, but Board Member Telesford. Can you try one more time, Board Member Telesford?
Yes.
thank you. Board Member Badlamani,
Yes.
Board Member Wingfield,
Yes.
Board Member Wetletter,
Board Member Whitletter, I believe you're muted.
Yes,
thank you.
sorry.
Board Member Wright,
Board Member Wright, I believe you're muted.
Or try again.
Oop, Board Member Wright?
Can you hear me now?
Yes, we can.
No.
motion passes.
Thank you for that. We'll now move on to our second public speaks. Give me 1 second, let me bring up the notes. Okay, once again, we are now at our second public speaks. This is time for you to share your concerns about an item, but not time for dialogue with the board. The board requests that you state your name and town of residence for the record. We'll set the time to 3 minutes and ask each speaker to respect that time limit. We must cut you off so it does not appear as if we're giving anyone an advantage or to share their views over another individual. Speakers have the full protection of free speech during public speaks. However, this forum does not protect you from the subject of your free speech pursuing libel or slander charges. And finally, the board recommends that all members of our community follow the chain of command. All right, our first, we have audio public speaks from Marion Rabb. Mr. Bonds, is that committee member on?
Good evening. Can you hear me?
Yes, we can. Good to hear from you again. You have 3 minutes.
Thank you so much. I really appreciate it. Good evening and welcome to the 3 new board members. My name is Marion Rabb and I'm a Maplewood resident. I have a 9th grade special needs student at Columbia High School, and I also have a recent graduate of Columbia High School who is currently doing a gap year. I wanted to thank you literally from the bottom of my heart for getting our schools back open today. It was no small feat. I am aware of that. We are all trying to do what I like to say are normal things in extraordinarily abnormal times. You know, speaking of substantial disruptions, our children have had their education substantially disrupted, unfortunately, because of COVID. Not just my kids, but the other 7,000 plus kids in this district. And I really don't want to repeat myself, but thank you, thank you, thank you for getting our schools reopened today. I know it was no small feat. And I'll be perfectly honest with you, I was pretty sure I was among quite a few parents last night waiting with bated breath, trying to literally praying that we weren't going to get a 6 p.m. phone call that we couldn't get back and we were going to go virtual another week. So it was a big thing. As I said before, and as I know you know, our kids have been extraordinarily impacted by the long stretch of virtual schooling that this district unfortunately had to do between the start of this, I'm going to call it an endemic because I think it's an endemic now, in March 2020 until September 2021 when we reopened in person. And special ed kids, I know you know this, but I have to say it again because these kids cannot speak for themselves. Special ed kids have been exponentially impacted by closing schools and going virtual. As I mentioned last week, and I just want to say it again, one of the most universal cultural values is that adults are supposed to be responsible for the welfare of children, not the other way around. We see numbers going up. It's scary. I know we're all living through this together. These are unprecedented times. But thank you once again for getting our schools back open. And I ask you, as the weeks and months, as we get through the next few difficult weeks and months of this spike in the endemic, every single public health officer in this nation is saying that we must keep schools open. Schools need to be the last thing to close when numbers start to spike, the absolute last thing to close and the first thing to open back up. I know we've all said this before. I just think it bears repeating. We need to believe the science and the data. Please don't push that to the
Thank you,
side
Miss.
and give in
Thank
to any
you.
fear
Your time is
mongering
up.
and or hysteria that can happen in situations like these. Thank you and good evening.
Thank you. Your time is up. Thank you. Sorry about that. All right. Our next public speaks is from old friend Shannon Cuddle of Maplewood. Let me set the timer. This is a written comment. Welcome to new board members and Happy New Year to all. I am writing to say I'm very happy that the board is receiving HIB training tonight, and that is very valuable and important. Thank you for making that commitment to better training and understanding. HIB training is not just one and done, and anti-bullying overall also includes looking at the climate and culture of a classroom or community. Training and understanding of the definitions and understanding of what harassment, intimidation, and bullying look like inside and outside of the classroom, online and offline. I would encourage the board to expand training to include anti-bias and include cultural competency, climate and culture, and continuing the discussion. If we don't understand what our climate and culture looks like, and for students and families to understand how to find support, guidance, and crisis support, we will be missing creating inclusive, safe spaces for all students. Thank you, and I know we made a commitment as a district, and thank you all. And that concludes our second public speaks. I think we'll now move on to new business. Is there any new business this evening? All right, seeing none, I'll close new business, and I'd like to make the following motion. The Board of Education will meet in closed session Monday, January 24th at 6 p.m. in the Superintendent's Office, 525 Academy Street in Maplewood, as well as using the online video conference platform to discuss personnel, legal, negotiations, and other matters to be noticed at a later date. Immediately following the closed session, the Board of Education will meet in public session Monday, January 24th at 7:30 p.m. at 525 Academy Street in Maplewood, as well as using the online video conference platform. Action will be taken. For those planning to attend in person, please note that masks and social distancing are required by the local departments of health. May I have a second? Thank you, Board Member Bergen. All in favor? That's unanimous, Mr. Burnside, and I'd like to close this meeting at 8:44 p.m., Monday, January 10th. Good night, everybody. Stay safe and be well.
Have a nice night.
Good night, everyone.